to AN's webinar, A Conversation with Kenneth Marcus on Law, Jew Hatred, and Higher Education. I'm Miriam Elman, and I'm the Executive Director of AEN, and I'm really delighted to welcome to this event our faculty members from across the country, our supporters, university leaders and administrators, and colleagues from partner organizations. And Ken, it's really a pleasure to host you today. You've been a longtime colleague and a friend of AEN, and we're really delighted to have this opportunity. Before we begin, I'd like to thank Oren Gross and Daniel Gordon, who co-organized this spring webinar series for us. Oren chairs our section for faculty in law, and Dan chairs our interest group for faculty in the Northeast. Dan Gordon is professor of history at the University of Massachusetts and has published extensively on the French Enlightenment and on contemporary intellectual and legal history. Oren Gross is the Irving Younger Professor of Law at the University of Minnesota Law School and an internationally recognized expert in the areas of international law and national security law. And so Dan and Oren, we in the leadership team are so grateful for all your work to plan and to organize this webinar series, and of course for your ongoing commitment to the Academic Engagement Network. And with that, I'd like to turn the floor over to Oren. So Oren, please go ahead.
Excellent. Thank you, Miriam. And good morning, I guess good afternoon for those of you on the East Coast. Welcome to the third conversation in the series organized by the AEN section for faculty in law together with the AEN section for the Northeast. And it is my great pleasure to introduce our speaker today, Ken Marcus. I would note that whereas Ken faces the challenge of condensing a complex issue into 20-25 minutes, my challenge is actually greater, namely having to take Ken's extensive resume and boiling it down to a brief introduction. Ken is a former Assistant U.S. Secretary of Education for Civil Rights and the founder and chairman of the Louis D. Brandeis Center for Human Rights Under Law, which aims inter alia to combat anti-Semitism in American higher education. And I have to say, on whose academic advisory board I am proud to serve. In addition to his hands-on experience fighting anti-Semitism in the trenches, so to speak, Ken has authored the definition of anti-Semitism with Oxford University Press in 2015, which is a must-read to anyone thinking about anti-Semitism, and kind of not to get Cambridge University feeling bad. He also published The Jewish Identity and Civil Rights in America with Cambridge University Press 5 years earlier. Ken is also a previous holder of the Lillian Nathan Ackerman Chair in Equality and Justice in America at CUNY's Baruch College of Public Affairs, and currently a visiting research professor of political science at Yeshiva University, a member of the editorial board of the Journal of Contemporary Anti-Semitism, and chairs the executive committee of the Federalist Society for Law and Public Policy Civil Rights Practice Group. I can think of no one better to address the topic of law, Jew hatred, and higher education than Ken. And before I turn it over and turn the virtual floor to Ken, I will just know that those of you who are interested in asking questions, you can start putting your questions in the chat. I will try and call on you, maybe kind of combine questions together and try and keep your questions short. I know there will be a lot of interest and lots of questions, and we would like to hear our speaker. And with that, Ken, the virtual floor is yours.
Thank you, Oren and Miriam and Dan. It's a pleasure to be back to AEN. I've had the honor and the pleasure of speaking to AEN audiences before, usually in a swanky hotel as opposed to my own house. I would say that in those hotels, the food is often better than here, but I found the parking to be very easy here in my driveway this morning. So I think it balances out in in the end. It's an interesting time to be discussing anti-Semitism on college campuses, despite the fact that we barely have college campuses right now with remote education. Nevertheless, we still have campus anti-Semitism, which is to say, we still have cases coming in all the time, even with remote learning and the limitations on social interaction. But the climate in which this takes place is continually changing, with new and unfortunate and often hurtful and hateful efforts to exclude Jewish students, especially if they support Israel in some fashion, that we're seeing all the time, complementing in some ways the BDS efforts that continue to happen. But on the other hand, we have, with the IRA definitions, rapid spread around the world, new tools to address it. With IRA implementation being argued on many campuses around the country. So right now is definitely a time when we have both increasing problems despite the limitations of COVID, but on the other hand, with the IRA definition, sort of a new battlefield that's opening up. My background, as you kindly pointed out, involves centrally efforts through the federal government to address anti-Semitism consistently with the way in which federal civil rights law addresses other forms of hate and bias. And I've approached it in this way because it seems to me to be right and obvious and consistent with the way in which civil rights is generally practiced. But it also has been an important and different way of looking at things. Oftentimes, what some people see as being mere disagreement over politics has to be understood not only that, but also as a form of hate or bias. And this reframing is not only a strategy, but it's a way of understanding what is in fact going on beneath the surface. In doing so, the challenges were from the beginning fundamental. It was nearly 20 years ago when I started looking at this issue, when I first arrived at OCR, the Office for Civil Rights at the U.S. Department of Education, and inquired about what the agency was doing with respect to religion issues. I had come from a fair housing background, and the Federal Fair Housing Agency, which I had previously run, like other civil rights agencies, addresses religious discrimination consistent with the way in which it addresses sex discrimination, racial and national origin discrimination, so on and so forth. But when I reviewed the jurisdiction of my then new agency, OCR, on the website of the Department of Education, I read that OCR handles discrimination 10, 15, lately sometimes even 17,000 cases per year on the basis of race, color, national origin, age, sex, disability, membership in certain patriotic organizations like Little League Baseball or Boy Scouts of America. But religion was omitted in what I initially thought was a webmaster's mistake, but which I later found, and we could discuss, but what I later found was an intentional omission by Congress when Congress passed the Civil Rights Act of 1964 and included religion together with race, color, national origin in many different parts of the Civil Rights Act of 1964, but not in Title VI. Not in Title VI. There are many cases that by rote recite the different categories of protected coverage under Title VI as race, color, religion, national origin. But in each case, and I tracked them down years ago, it was a mere error. It must have seemed odd to omit religion, whereas either religion or creed had been included in all of the predecessor legislation and in numerous parts throughout the Civil Rights Act of 1964, even where religion didn't seem to make a lot of sense. But it was taken out of Title VI, which applies to discrimination in federally funded programs or activities like colleges and universities or public schools. So at that time, I asked around about anti-Semitism. This was around 2002. And at that time, we were beginning to see what looked like an influx of new incidents around the country, especially on the West Coast, at San Francisco State, and then at Irvine, but also we were hearing some buzz around Columbia University and some other institutions. And it seemed to me at that time that a statute that prohibited discrimination on the basis of race, color, or national origin, but not religion, should nevertheless include anti-Semitism. I did not at that time consider myself an expert on anti-Semitism. I'd not written even a single book on the subject. And yet it had been my sense that anti-Jewish hatred is not always motivated by the tenets of a Jewish religious faith, but is sometimes associated with stereotypical views of what it means to be Jewish in an ethnic sense. And yet I was told at that time, 2002, 2003, that the Department of Education did not have a formal policy on whether Jew hatred was included, but that it had looked at the issue from time to time since at least the Carter administration, which had established education out of what had been health education and welfare. And the frequent, if not fully consistent decision had been that Congress had chosen in 1964 to delete the word religion from Title VI, and the Education Department did not have authority to put it back in. Moreover, as a policy matter, Hitler was the last prominent politician to view Jews as members of a race, and no bureaucrat at the Department of Education wanted to follow in his footsteps. So there was both policy fear and also a sense of inappropriateness about adding back religion. And so OCR ignored anti-Semitism cases. When a Jewish student would come in saying that they faced at their public school or college or university some form of harassment, they would get a sympathetic rejection. You can hire your own lawyer and go into court, but we will not investigate. There will not be a federal investigation by the Department of Education and a threat to eliminate all federal funds if there is a finding of violation of Title VI. That you won't get, as you would if you had a claim based on national origin. For instance, if you were an Arab American saying it was a national origin discrimination, or for race or gender or anything of that sort. So at that time, I asked my colleagues to call in to headquarters if anyone came into any of OCR's 12 regional offices with any claim that has anything to do with religion. And the phone rang in New York when a New Jersey father said that his son was beaten up and called Osama because of their shared faith, Sikhism. And so I said at that time that I understood Sikhism to be one of the world's great faiths, but also potentially more than that, that Sikhism shared origin in a particular part of the world, common language, custom, etc. And that the circumstances of the case, despite the father's apparent assumption that it was faith-based and therefore religious, that this was a legal determination to be made by OCR, and that there was nothing about the harassment or the pejorative to suggest that it was necessarily based on tenets of theology, as opposed to either could have been perceived anti-Arab or anti-Muslim or actually anti-Sikhist. So from that, I built what became a Dear Colleague letter, which took the following position. If someone faces harassment or discrimination based on membership in a group which shares both ethnic or ancestral characteristics and also a shared religion, OCR will assert jurisdiction to the same extent as if that group shared ethnic or ancestral characteristics, but no religion. That a group could not lose civil rights protection that it otherwise had merely because of a shared faith. I call that a clarification because OCR on its own did not have authority, certainly in sub-regulatory guidance, to change rights or regulations, but I believe that it was merely clarifying rights that existed implicitly within Title VI as a statute. My view then, as it is now, is that to prohibit discrimination on the basis of race, color, and national origin is implicitly to include groups like Jewish students who share a common ethno-religious background. And I anchored this in Ashari Tefillah versus Cobb. Some of you may be familiar that there were, back in the 1980s, multiple litigations going through the court systems involving both anti-Arab and anti-Jewish discrimination. And St. Francis College, the allegation that an Arab professor faced discrimination in employment, and in Shari Tefillah congregation in Maryland, an allegation that various Jewish property, both individual and communal, had been vandalized by essentially white supremacist anti-Semites. And as the two cases went up simultaneously through the court systems, the Arabs under a 19th century civil rights statute that barred race discrimination, but not religious discrimination. And as this proceeded through the courts, the Arab man consistently won, whereas the Jewish plaintiffs lost. But fortuitously, the two cases arrived at the Supreme Court at the same time. And in unanimous decisions, the Supreme Court held that both anti-Arab and anti-Jewish discrimination were both covered under the statute, the post-Civil War civil rights statute, based on what you might call a shared public meaning, form of original intent, which is to say the court looked at congressional floor debate and found that there was a general agreement that Jews and Arabs were covered, and also at encyclopedias and other reference books, which also generally covered Jews and Arabs. But the pushback that I got from my dear colleague letter of 2004, holding that Jews and others would receive this protection, was that things have changed, and that it's one thing to say that in the 1860s or 1870s, Jews were considered to be members of a distinct racial group, but in 1964 it was different, and that the same rationale under which Jews should get protection under the 19th century Civil Rights Act undermines a claim that they should get a protection under the Civil Rights Act of 1964. But my response at that time, and which is largely held up, although there's been limited litigation on this, was that if you look at the cases in which courts have looked at the Civil Rights Act of 1964 and compared its protections with those of either the Equal Protection Clause or the 19th century Civil Rights statutes, and I'm talking about really the affirmative action cases from Bakke to the Michigan cases, the court consistently holds that the rights protected under the Civil Rights Act of 1964 are coextensive with those of the 19th century, because members of Congress were clear in 1964 that they were not establishing new racial protections, but rather establishing a new mechanism for addressing violations of rights that were defined during the prior century. And for that reason, the rights protected in 1964 could be no less. So for that reason, my 2004 Dear Colleague letter a sub-regulatory guidance document coming out of OCR, indicated that Jewish students and others who face ethnic and ancestral discrimination will have the same protection as if the group had no religious claims. That clarification lasted as long as I did. By 2004, I'd been appointed to a different position in a different department, and my successors were not following the guidance. They took a different view. There were several different reasons, I think, that the 2004 policy was controversial. There were conservatives who were accustomed to reading civil rights statutes narrowly and who thought that I had taken an overly broad interpretation. There were liberals who thought that the federal government's power should be focused on protecting underrepresented groups and not groups like Jews who have privilege and power. And then there were bureaucratic traditionalists who simply don't like change and who were uncomfortable with what appeared to be change in position. So I would say between 2004 and 2010, the policy that I had written was still on the books, but it was not enforced. And when asked about it publicly, officials would say, of course, we're doing it the same way that Marcus had done it. But when deposed about it, they would admit under oath that they were not. By 2010, I had left the government and was working with a coalition of Jewish organizations, which convinced the Obama administration that it was necessary to speak up on this. And to their credit, they did. And my successor, Assistant Secretary Ruslan Ali, during the Obama administration, issued guidance in which she said that essentially that the policy that I had written was still valid, and in fact she expanded on it and fleshed it out in ways that were useful. So now we have 10 years since 2010 that OCR is once again saying that it is going to address anti-Semitism. The problem is, first, very few cases were brought, despite various indicators suggesting a large amount of anti-Semitic incidents on college campuses. Very few actual cases were brought. And to the extent that they were brought, often they had to do in some fashion with Israel. In some way, shape, or form, the anti-Semitic animus was expressed, at least in part, in ways that connected with Israel. And the OCR did not have a means of distinguishing between what is merely political and what is in fact biased. There was no standard, there was no guidance, there was no definition. So I began arguing at that point that OCR should adopt standards and preferably a well-established definition of anti-Semitism to distinguish between what is and what is not anti-Semitic, so that one could look at cases. The notion wasn't that anything that's anti-Semitic is therefore a violation of Title VI. Of course, there are lots of things that you could say are racist or sexist that don't violate Title VI or Title IX. But you need to know if something is on the basis of race, color, or national origin. In the same way, you need to know if something is on the basis of sex. And a well-established definition can help you do that. The definitions that I suggested were all variations on what we call the working definition of anti-Semitism. We now refer to it largely as the IRA definition. I would say back a decade ago, I used the term EUMC or UMAC definition because it was the European Union's Monitoring Center on Racism and Xenophobia that had first crafted the definition based on input received from a number of scholars and NGO representatives. Later on, during the Obama-Biden administration, the U.S. Department of State crafted its own definition that is substantively the same as the EUMC definition. The Obama-Biden definition, I would say, did a better job of emphasizing the core of the definition within the examples relative to Israel, which is to say the Obama-Biden State Department definition emphasized the 3Ds from Natan Sharansky. That is to say that not all criticism of Israel is anti-Semitic, but if one sees delegitimization of the state of Israel, demonization of Israel, the use of double standards, that there might be something at play different than in other forms of dispute. In 2019, I was back at OCR again, having been confirmed as the Assistant Secretary for Civil Rights. And the arguments that were in my second book and that others had made also for why OCR needs to have a standard definition had prevailed, not before Congress, which had come close to passing the Anti-Semitism Awareness Act, which would have codified the working definition of anti-Semitism, but rather in President Trump's executive order on combating anti-Semitism, which provided that OCR and other federal agencies should consider the working definition of anti-Semitism to determine whether a certain conduct has been motivated by anti-Semitism. That is to say, the executive order, which closely paralleled the Scott Casey Anti-Semitism Awareness Act, did not say that any anti-Semitism, anything that's anti-Semitic within the meaning of the working definition of anti-Semitism should be considered a violation of Title VI, but rather that appropriate officials should consider it for very limited purposes. If there is conduct that would meet the standards of Title VI, if it's anti-Semitic, then officials should use the definition when appropriate to determine if it's anti-Semitic. That executive order, although initially I would say misrepresented in a first round of news coverage driven by the New York Times, I think now is a little bit more broadly understood. The Biden administration has archived all of the executive orders of President Trump, including this one. It has rescinded some of them, but not others. The executive order on anti-Semitism is one of the orders that has not been rescinded. It has been merely archived within the White House website. However, it is an executive order, and so it also appeared in the Federal Register at the time and is now within the CFR. So while it's in the White House archives, it is in the CFR. And moreover, the Office for Civil Rights developed an FAQ document as a form of subregulatory guidance that essentially incorporated the executive order and placed that within its portal of active policy, which is to say, while an executive order is important for the president, for the bureaucrats at OCR, it's important to signal whether something is or is not active policy of the agency. And so it's notable that the executive order resides not only on the CFR, but also in the active policy portal of OCR. So that brings us to where we are today, which is to say there is a new administration which has taken place. There have been somewhat mixed signals on this issue, but we know that Secretary Blinken and his senior staff have indicated that they strongly embrace the definition. And we have seen around the campuses now several student governments adopting it, and a handful of university administrations doing the same. I think that right now, the most interesting and important activity that's being taken place to fight anti-Semitism consists of the efforts to incorporate the definition further, both in terms of the Biden administration's policy and also in terms of the work that's being done on campuses around the country. It is now 12:30, and so based on the directives I got at the beginning, I would be happy to turn over to any questions or comments.
Thank you, Ken. This was really enriching. And you know, you said that based on the directive that you received, we can always archive those directives if you need more time. But we have a healthy queue already, and I invite others who want to ask to join. What I will do is I will call on people to unmute themselves and ask their questions. I'll try, if there are questions that are connected, to combine them. Try and keep your questions short. Some of the questions that I already saw can open up to a whole different lecture. In fact, at least one of them did connect to a previous lecture. But I want to call on Dan and Renee that basically have, I think, questions that are touching on each other. Dan, if you want to unmute, or you're unmuted already, and go ahead.
Thank you for an excellent talk. I'd like to play devil's advocate for the sake of generating discussion. Some critics of the IRA definition suggest that it limits free speech. I would add that it is, after all, a foreign organization that created it, and it is a bit unusual for the United States to defer to non-American legal sources. So I'm wondering if you could speak to the thorny issue of free speech versus non-discrimination to make it as complicated as possible. I'm wondering if you would agree that boycotting Israel is a First Amendment expression. I think the Supreme Court has said that boycotts are a form of free speech, and that the state laws banning contracts with people who boycott Israel are on pretty shaky ground, precisely for First Amendment reasons.
And Ken, before you answer, let me just call on Renee as well, if you want to unmute and kind of add your question, and maybe try and be a bit more specific than the free speech, hate speech. If you have any concrete.
Great. Hi, everyone. Renee Blumenthal from the Marcus Foundation. Probably somewhat tangentially related to what Dan just posed. You know, just the whole issue of free speech versus hate speech, and how a lot of college administrations just hide behind everything is free speech. So how, what do the laws tell us? How do, you know, if we want to affect change in anti-Semitism, where are the levers that you can push on college campuses and administrators when they hide behind free speech as hate speech?
Okay, excellent. Thank you, Dan and Renee. And by the way, I'm just noticing lots of other friends also are on. So it's both an honor and a pleasure to be speaking with all of you. So I've got several different pieces here about the foreignness of the so-called IRA definition, the free speech issue generally, and with respect to boycotts, and the levers or techniques that we can use in dealing with universities that hide behind free speech. So first, Dan, I'm always a little tickled when I hear the argument that why use a foreign definition when in fact the U.S. has unique laws and rules, including the First Amendment. And this argument is usually not made by people who accept the notion of American exceptionalism in other respects, but do so here. Of course, IRA is not a foreign organization. It's a international organization with dozens of participating states, of which the U.S. is a part. So it is no more foreign than, say, UNESCO, or, well, actually, it's probably less so than UNESCO at the time. No more foreign than the United Nations, say, or OSCE, or other multinational organizations. But the IRA definition does derive from the EUMC, the European Union Monitoring Center's definition, and the United States is not a member of the European Union. So you could say it's based on a foreign EU definition. What's ironic about that is that one of the challenges within the EU at the time was that the definition was considered to be too American, because while there were representatives, scholars, and NGO representatives from Europe, Israel, and the United States participating in it, I think that there was a notion that Americans had been disproportionately influential. There were multiple U.S. scholars and advocacy organizations involved. And at one point, I think that there was some kerfuffle about the use of an American spelling of a word as opposed to a UK spelling of a word, which seemed inappropriate for an EU organization and seemed to reveal the sinister American influence on what was supposed to be an EU definition. So I don't know whether we can say that the working definition is foreign. Americans have played a role in its development from the beginning, and of course, the IRA itself is as American as any other multinational organization. As to the issue of free speech generally, I tend to be very strong advocates for free speech. And I do think that it is appropriate to be concerned about free speech whenever we talk about anti-discrimination law. And in particular, whenever we talk about hostile environment law, because it is rare for a hostile environment claim not to have some elements of speech involved. And yet there are few who are so extreme in their support of free speech that they would eliminate all hostile environment law. Rather, it seems to me that what one should do is to provide appropriate guardrails and standards so that speech is as carefully protected when it comes to anti-Semitism claims as it is with respect to any other form of discrimination claims. And with respect to all of them together, that we make sure that we are, people would say striking the proper balance, but my view is we need to do both. We need to protect speech fully, and we need to address discriminatory conduct fully as well. The speech conduct distinction is often used. It seems to me that if pure speech is anti-Semitic within the meaning of the IRA definition, it cannot be suppressed. It may be condemned in certain ways. It may be a trigger for certain actions of the university of a non-regulatory manner, such as education or outreach or orientation or things of that sort. But it seems to me that we should not be using the IRA definition or the executive order to suppress speech. Rather, we should be using it both as a basis for education, training, orientation, and also as a means of properly addressing those forms of conduct that are not protected by the First Amendment, the doctrine of academic freedom, or basic principles of free speech. There was also a question about application for boycotts, which of course is a complex area unto itself. So the Supreme Court has held that boycotting is generally an expressive activity. It seems to me that speech in favor of a boycott should be considered protected, and yet boycott activity in itself is a form of conduct, which, when it is intended to be when it's prejudiced or based on bigotry, is outside of the usual rule. The Second Circuit Jews for Jesus case, I think, provides some useful direction in that as well. And the last piece of the two questions, I think, was Renee's on what can one do when universities try to hide behind the First Amendment. And I think that the hiding term is appropriate, because we have seen cases where universities insist that they're not going to do anything about anti-Semitism, and yet they will crack down on what appeared to be a pure expression on the same campus. Often we will deal with administrators who seem like First Amendment purists when it comes to anti-Semitism claims, and yet on that same campus will find completely different behavior. So one of the things that one can do is to show that discrepancy, and it's often there. Take a look, for instance, at what the fire report card is for the campus and how they've been handling things. I don't think we should say that if they've suppressed speech before, they should suppress it again, but they should be consistent. I also think that the ask is important, and the ask should seldom be to punish a speaker. There may be exceptions. For instance, there are some forms of speech that are clearly not protected. Speech on a non-forum, like vandalism carved into a student's door, would be one example of an exception. So I think we should be careful to be and to present ourselves as supporters of free speech. I think that, but I think we should spot hypocrisy when we see it.
Thanks, Ken. You kind of ended the presentation with where we stand currently with the Biden administration. And Jonathan, I would invite you to unmute if you want to follow up on your question on the Biden administration and the and Title VI.
Thanks, Ken. I would just invite you to share your thoughts. What are things that we should look out for? What kinds of what kind of cases may be brought? What kinds of things should we look for in the responses that we may see? And what's your analysis of how things may go from here with a change in administration and a change at the DOE?
Sure, thank you. So, often when people ask that question, they're focused on the most recent gain from the outgoing administration, and they want to know, will we maintain it? And that's a good way to start the question, but I always like to think also, what are the unique gains that we might see from the incoming administration? I think at this point it is unlikely that the Biden administration will simply rescind the executive order. That would be a politically difficult thing to do, and probably not necessary for them to do, even if they were, even if their intent were bad. So I don't see them rescinding it. I know that there have been many efforts in both directions, efforts by Jewish communal organizations to have them maintain it, and efforts by critics to have them rescind it. And at this point, we have them with the status quo. The question is, will they apply it? Will they administer it? And will they speak out? So I would like to see them using it under appropriate circumstances and saying that they will use it and doing it in a way that is sufficiently transparent and hopefully vocal that others will hear them. But that's not enough, and I don't think that that's the best ask either. It seems to me that each of the past few administrations have improved upon the record of the prior administration on anti-Semitism in some respect. The George W. Bush administration was the first to establish that Jews would be protected under Title VI. The Obama-Biden administration not only affirmed that in 2010, but also expanded on it, fleshed it out, and then in the State Department adopted the working definition of anti-Semitism. The Trump administration built on that further by applying the working definition to U.S. campuses and establishing that Title VI should be interpreted in light of it. So each of the three last few administrations have, in their own way, made an advance. I would like to see the Biden administration make its own advance. Now, you ask about cases, and it may be in effective use of cases. I think the Trump administration was the first to actually take cases to the point of actually having resolution agreements that required universities to do things in response to anti-Semitic activity. That was the first. Maybe there will be more, and there are now more cases pending before Biden than I think that there have perhaps than ever having to do with anti-Semitism. So they'll have an opportunity. But their best gains might not be on cases, but rather on a combination of policy and communications. The Trump administration issued very few Dear Colleague letters. The Obama administration did more in the way of sub-regulatory guidance. There are legal and policy reasons why there haven't been many sub-regulatory documents in recent years. The Biden administration might have a broader arsenal of weapons or tools that it uses. So either through guidance or through communications, I would like to see the Biden administration communicate to administrators that it is as serious as any prior administration at dealing with anti-Semitism. And significantly, I'd like to see them signal that they're concerned with anti-Semitism regardless of its form, whether it comes from the right or whether it comes from the left, whether it deals with Israel or whether it does not. It's too soon to say whether it will or not. We don't even have all the key officials confirmed, nominated, or even named. So it's too early to know for sure. But I think it's best to go into this with an open mind, to come up with the different ways in which the new administration might score some victories in our area, and to encourage them to do it.
Thank you. The next three questions, in a sense, are, I would say, are closer together. I would classify Diane, I don't know if it's a comment or a question, and Gary definitely has a question, as a classificatory questions, and Ernest's question as an anti-classificatory question. So let me start with Diane and then Gary, and then have you Ken answer them, and then turn to Ernest. So Diane, do you want to unmute?
Yes, thank you. Hi, Ken. Nice to see you again. My point is that in the 1940s, after the liberation of the concentration camps, when the United States government is running DP camps, they make the decision that Jews are a national group. And they separate the Jews out because originally, using exactly that Hitler quote, they say, well, we can't, separate Jews and Germans because that's what Hitler does. So they put the Jews in with the German POWs, and then the Jewish survivors are killed or beaten up, especially since they are guarded by Wehrmacht former soldiers. And we have Benjamin Harrison, who's the dean of Penn Law School, comes and gives the Harrison report. And Truman and Eisenhower work together, and they say, yes, Jews are a national group. We are going to put them in separate camps. They are going to run their own offices, and we are going to do this throughout the period until the U.S. High Commissioner leaves in 1955. So I think we do have ample evidence that Jews by the United States government have been treated as a separate national group, and an understanding, which in this current climate I think is very important, of the special, unique characteristics of Jews who are a religion and are a national group. And as I say, that we have a jurisprudential and government history of that, and perhaps we can use this going forward.
So speaking of protected groups, Gary, do you want to unmute and ask your question?
Sure. Thank you very much. Thank you, Mr. Marcus. I really enjoyed and learned a lot from the presentation. Just a very quick question. The kinds of debates, the kinds of issues and the debates that you've been dealing with in your professional life and that you've described here, are there also definitional questions about other protected groups? So other race, other religions, other races, other, I guess national origin would be a little easier to define precisely. But is anti-Semitism somehow exceptional in dealing with how to apply Title VI and other pieces of legislation? That's the question. Thanks.
Shall I dive in, Oren?
By all means, and then we'll take Ernest. Actually, you know what, Ernest, do you want to add your kind of the end of your question? I guess we can pull in as well.
Oren, are you speaking to me? This is Ernie Sternberg.
Yes.
Okay, I do have to remind Ken I have to leave pretty soon. So the end of my question is, can I object to being labeled as white and understood in the capital W sense as an ethnic identity that I reject? I'm pale-faced, but I am not ethnically white, and I don't identify with that. I accept that identity. However, nowadays, you may be spared from being on campus nowadays. I'm in Buffalo, and that kind of direct discussion and addressing of each other by these labels happens all the time, and getting very upset about it. So my question is, do I have a legal basis for rejecting being categorized as white and saying I'm an other?
This is great. It's good to see you, Ernie. I've not heard anyone self-describe as pale-faced as an identity
Right.
before, but that's intriguing. Well, I'll start with Diane's, just saying that I found that history to be interesting and useful. I don't know where you were in 2002 when I was struggling with the issue, but it certainly is good background. So I'll go to Ernest's question. Yes, I see that a lot. It was an issue a decade ago when I wrote my first book on this topic, and it is perhaps an even bigger issue right now. We do frequently see both faculty members, college faculty members, and also high school teachers who are being required to take either different training if they are called white, or to participate in different group discussions if they are white. And I've seen cases where they've balked and been told it's not up to you. You are socially perceived as white. You need to own the privilege that comes from that social perception. I'm not sure exactly how to take your question, Ernie. I think you asked a specifically legal question. There's right now the social question, and it is very difficult to challenge that. We've seen students who are essentially told they need to be treated as white because they're Jewish, even if they are not Ashkenazic Jewish. They might, for instance, associate as biracial. One of our students considers herself to be a Caribbean Jewish. We've had faculty members who consider themselves to be non-white, not just in the sense that they consider Jewishness to be something different than white, but in other respects as well. There's quite a literature on this. I've surveyed part of it in my book on Jewish identity and civil rights. As a political matter right now, it's difficult in this particular moment to make that argument. But I respect those who consistently do that. I can see a potential case coming up in which Jewish faculties complain about the way in which they're treated based on a combination of stereotypes, anti-Jewish stereotypes and anti-white stereotypes, including the notion that they as Jews have particular white privilege. But we don't have a whole lot, a lot of precedent there.
My question, Ken, is not specifically about Judaism, but can an administration compel a categorization of a faculty member or even a student?
Compel a categorization. Well, the employers, especially if they're government contractors, are often required to categorize employees. They'll usually ask an employee what their race or national origin is, and if they're not given an answer, they'll indicate refuses to respond, but then they'll often be required to come up with their best guess, and that's not been struck down. I don't know if it's been challenged. So I think that the case that we might see coming up is one where a particular identity is imposed on Jewish faculty or Jewish students or employees. And we see that a lot, where they're told, you must go to this particular, white, this room for whites. In Evanston, Illinois, there was a case that before OCR last year, where teachers were told that if they were white, they had to go to a particular training. If they're non-white, a different one. There was also one of these, I forget what it's termed, one of these exercises in which people are to line up, and if they're white, they step forward, and if they're not white, they take a step back. OCR last year found that there were violations of Title VI in this, both as racial segregation and violation of Brown versus Board of Education, and also in the use of invidious stereotypes. And so there was a finding of a violation there, which was considered significant enough that OCR actually highlighted the Evanston case in its year-end report to Congress that came out just a few months ago. In an extraordinary reversal, OCR just a month or so ago pulled back its findings. I don't believe it had ever done so before. There was only one instance when OCR had pulled back findings. It involved the University of Virginia in a Title IX case in which OCR pulled back findings based on an admission that it had made factual errors. That was the first withdrawal, but this and Evanston was the first time that it had withdrawn findings based on a change in legal interpretation. So OCR pulled back the Evanston determination based on an apparent inconsistency between Evanston and the Biden executive order on systemic racism. So currently, with the Biden administration, I think the view is that the executive order on systemic racism would preclude the sort of challenge that I think you might have in mind. What the courts would do with it, I think, is sort of a different question.
Just go back to Gary's question on other protected groups, if you want to touch on that.
Thank you. Well, I mean, there are long-standing definitions in civil rights laws for sexual harassment. I would say that that's the best example of a well-established definition that exists within various, certainly sub-regulatory and also regulatory guidance, which has now been widely used also by universities and other employers. I would also say that reasonable accommodations under the ADA and other disability law is very widely defined. Those are the two examples that I would come up with that are subject to common definitions. And while there isn't a single definition of either, like the IRA definition that has precise wording and international acceptance, I think you will find much of the similarities in terms of sexual harassment definitions from one university to another, because it's all based on federal law. We don't really see it so much under Title VI or other statutes. There are often questions about what is discrimination on the basis of race, but it doesn't usually come down to a particular definition of that sort. I think that there have been recent efforts in the wake of the working definition of anti-Semitism to come up with definitions for either anti-Muslim discrimination or other sorts. But the general notion is that anti-Semitism calls out for the need for a definition in the way that others don't, because there are such frequent and debilitating battles over what it means and what is anti-Semitic and what is not.
So we are down to the last minute to what we as competitive chess players call bullet chess. So Steve, if you want kind of in 15 seconds and then Ken in 30 seconds respond, and we can wrap up on time. Steve, that's off.
Mute. I just wanted some discussion of this Jerusalem definition, which seems to me it's just made up as a ploy to deflect whatever the real discussion is into something minute, so they don't have to really deal with the issue. Your thoughts on that?
In the future, we will all have our own definition of anti-Semitism. I actually published one, they published theirs. There's this nexus definition. I look forward to the definition where a time where we have dozens and dozens of definitions. There are various academics. I think Carrie Nelson might be on the line, and I think that he's published a nice refutation, substantive refutation of that definition. I believe it's on Fathom. There are others who have pointed out flaws in the definition. To me, there are flaws in the definition that Carrie and others have pointed out, but the biggest is that there's value in having a single international standard. And even if some of these other definitions had substantive strength to them, it still would be unhelpful to deviate from an international standard. After all, one of the main reasons for the international working definition was to have consistency and allow for comparisons. So even if the Jerusalem Declaration had a point and were strong, it still wouldn't be, it still would be unhelpful. A number of years ago, a group of scholars gathered in Tel Aviv to discuss the working definition. And the first question was, do you think we can improve on it? And of course, no self-respecting scholar would admit that they couldn't improve on it. So everybody thought that they could improve on it in some respect or other. But they all had a different reason, and nobody could convince the others that their reason was better. And so at the end of the day, they decided, well, you know what? Each of us thinks we could improve in some respect or other, but none of us have really convinced the others. And at the end of the day, what's more important is to simply have a definition that establishes an international standard. So let's not mess with it. Because it does work. It's called the working definition. It's not called the perfect definition. It's not called the ideal definition. It's not even called the academic definition. It's a working definition, and it works. It basically works, and it is useful in large part because it is internationally agreed upon, because it's widely established. And so, even though at one point I thought I could improve on it, it seems to me that it does work and should be used for that reason, even if we imagine that we could come up with some improvement or other.
Thank you.
And for those of you interested, if I put on the in the chat the link to Carrie's article in Fathom. And actually, Ken, since no good deed goes unpunished, and you certainly did a good deed today, there was also a request if you could reference people, especially those who are not steeped necessarily in law, for references. You mentioned cases or articles, and obviously I will pitch in your book on the definition of anti-Semitism that people can follow up. So maybe through AEN, we can send such a list to those who registered for this talk, whether they're here in person or are going to watch this later at home. So before I thank you on behalf of everybody, Miriam, is there any other point of order?
Yes. Well, we can definitely do that list of additional resources. It's a great idea, Dan, and we'll get it to all the people who registered. Thanks, Ken. I know you probably didn't think you had more homework from AEN, but we're going to give you some, and we always appreciate it. I just want to say, before I turn it back to Oren for a thank you, that, we always learn so much from you, and you've given us a great deal to think about today. Everybody on the call, please be on the lookout for our post-webinar survey. And do remember that there's another 2 webinars coming up in Dan and Oren's webinar series. So again, I just wanted to thank Dan and Oren for all that you're doing for AEN and the very rich discussions that you've had for us, including today's, which has been terrific. So Oren, please go ahead.
Thank you, Miriam. And with that, really, all that is left is to thank Ken on behalf of everybody for a spectacular talk and Q&A. Thank you so much.
My pleasure. Thank you.